Thanks everybody for joining today. We have Sylvia Quezada with SQ Advising. Sylvia and I used to work together at a firm in Cedar Rapids. And so Sylvia recently started her own legal practice. And so I'm really excited to have her here today to talk about legal tips for entrepreneurs and small business owners. So thank you, Sylvia, for your time. Would you kindly introduce yourself to everybody?
Hi, Janie. Thanks a lot for inviting me, and hello, everyone. As Janie said, we both worked for rather large national companies, and I started my own business in 2019 as a small business owner myself. So I took all of the large legal department experience at the federal government and here in the Cedar Rapids Corridor, Iowa area, and bundled it up into both business law and consulting services to help budding entrepreneurs, existing entrepreneurs, and even those that are already had a successful trajectory with their business and want to wind up. So I'm available for consultations and for legal advising. You can find more information about me at at sqadvising.com. And I can be reached by telephone number 319-541-3321. And by email, I can be reached at sqadvising.com. I look forward to being of help and service to all of you entrepreneurs out there. You are the engine that makes America's economy thrive.
Thank you so much for that. So do you mind, let's dive right in and really get to, these are the questions that I get asked most often and that entrepreneurs kind of struggle with or get confused by. So let's go ahead and dive right in. So do you mind explaining what an LLC is?
Absolutely. So an LLC is the short term for the more longer form called a limited liability corporation. It's the most user-friendly type of corporate entity that an entrepreneur can consider. Of course, many factors and circumstances go into evaluating what corporate entity you want, but by and large, an LLC is very popular for starting entrepreneurs. The LLC offers a win-win situation for entrepreneurs on two fronts. The first one is limited liability protection, and two, pass-through taxation to the entrepreneur. And I'll explain to you, Janie, a little bit about what that means. For the limited liability protection, it basically means that on the corporate front, the member or members that started the LLC are protected from the liabilities that the operations of the business create. So for example, if there are equipment leases that are involved, if there's commercial leases, if there's any consumer litigation involved because of the services or products rendered, that is the type of liability that shields the entrepreneurs in an LLC. On the other front, called the pass-through taxation, it really involves the IRS and how the IRS works with and treats the LLC. So the IRS will very likely treat an LLC that decides not to elect an S corporation status as either a partnership if there are multiple members, or a single LLC membership member-owned company. And basically what that means is that the IRS will allow the profits and losses to travel down to the respective partners or the respective founder or owner of that LLC. So for purposes of taxation, in the first instance where you only have one single member who has created the LLC, that generally will mean that they will be considered a disregarded entity by the IRS, and losses and profits will flow down to that individual, and they will get to report it on their personal income tax at the bracket that they're in. For the partners or the group of members that have created an LLC, that will be determined based on the allocations that they have agreed to as a partnership to receive profits and losses. And the IRS does require these types of members to file additional type of tax reporting forms so that those losses and profits can be attributed to the right people in this multiple LLC that was created. And then there's yet again a third variety of the LLC that may have one or multiple members who decide to treat the LLC as a corporation. And of course, that brings in what I call the need to bring in your CPA to help you walk through what tax scenarios you'd be raising when you make that type of an election and not stay as a single member or as a pass-through partnership.
Yeah, thank you. For me, I think in the simplest terms I can put it into, I think of an LLC as kind of your legal protection. Like you said, it's a limited liability company, so it's protection for the business owner. And then you have the IRS business structure. So when you go to file your taxes, those are kind of separate. The IRS is still going to look at your business and determine what kind of business you're operating as and how you should be filing your taxes. So thank you for that wonderful
Yeah,
explanation.
and that's absolutely right. And you'll see that many of the entrepreneurs that start off will start off considering, well, what type of corporate entity should I become? And again, that's a super involved question with, what's your mission? What are your goals in the next 3, 5 years, maybe 10 years out? And by and large, most of the people that I've spoken to prefer the LLC because of the flexibility and the flexibility of filing taxes the way they were accustomed to doing before they became an LLC, and then the liability protection, that peace of mind that their car, their home, and their savings won't be involved if in case there's any legal issues.
Yeah. Okay. So then when should a business set up an LLC?
That's a really good question, and one that really depends on what I have advised a number of folks, and that is to consider two things. When do you need peace of mind? Peace of mind that, again, your bank accounts, that your home, that your extra car or your vehicles aren't involved in a legal battle over the types of products or services that you provided as an entrepreneur without the protection of an LLC. And then the second area that I advise folks is you want credibility from your business community. So if you have been a very successful caterer operating out of your home, and you've been catering businesses for your family, and it's a very small population of customers that have been happy and they have been safely provided these services, and now you want to scale to a larger population, then your risk is going up. And most likely that target population also wants to know that you're a bit more formalized in the services or products you're offering. So that's when folks may want to consider becoming an LLC, and that's to bring credibility to the type of work that they do, and two, that they're able to protect their personal household from any possible risks that come about from the products or services they offer to the public.
Yeah. Yep. Love it. Okay. So then if you are an LLC, if your business is an LLC, how will the IRS treat your business?
In what's in terms for filing for taxes?
Yeah. Yep.
Yeah, that's a good question, because a lot of folks will think about the protecting my household from the liability of litigation. But when it comes down to it, there's also this operational component or administration, secretarial type of work, and that is how you're going to file with the IRS. And that is going to largely depend on how big of a LLC you have. For example, are you a single member LLC? Basically, all that means is I, Sylvia, started my own firm. I'm an LLC, but I'm the only member of my firm. So the IRS will view me as a single member regardless of how I want to introduce myself to the IRS, as a disregarded entity. That's a fancy name for, it's a single member LLC. We're going to look straight down to the founder and treat them the same for tax purposes. Now, for liability, totally different, but for tax purposes, the IRS is going to look to me for my taxes on this LLC that I created. Now, if I'm a multiple member LLC where I have myself and right now, actually, I am working on the process of onboarding 2 other attorneys that happen to have been my colleagues in one of my prior law departments to assist me with the consulting work and the legal work here. Then we would be viewed as a partnership. the IRS is very clear at telling you this information. So if you look at their revenue, their publications on what it means to be an LLC, they walk you through this information: disregarded entity and partnership treatment status. Don't be afraid. If you find yourself being in a partnership status, all you need to know is, how did you agree as a partnership group to allocate the losses and the profits that this LLC generates? Because that's what the IRS wants to know. Who am I going to collect taxes from, and whether or not you can document that information accurately for the LLC.
Find that. I think that's very helpful for entrepreneurs. So aside from the protection of an LLC, what other protection could business owners consider?
Well, in terms of besides an LLC, or having an LLC?
Having an LLC.
Okay, sure. One very typical additional type of protection that LLC owners could consider, they don't have to, but I always say it's always better to protect your dream, your business, and that is insurance. And it's no different than the reason why you have car insurance or home insurance, and that's to protect against the unexpected claim that is successfully brought against your product or your service. So for example, if you have entrepreneurs that are in the business of providing consulting services or professional opinions, it's really important that they consider having errors and omissions insurance coverage. And it becomes even more important if they happen to have an office where they're inviting members of the public to come in. So now you need general liability coverage for those premises. If you're using a vehicle to transport your product or your services, then you're looking at maybe auto and collision insurance. So it opens up the possibility for a number of different scenarios where your products and services would need certain types of coverage. And then of course, if you happen to be an LLC that is in a position to hire, say, seasonal help, maybe you are a caterer that gets exceptionally busy at the fourth quarter with all of the holiday parties that companies have here in the corridor, then you probably need employee comp insurance as well. And then also maybe you might want to consider a rider for employment litigation insurance if in case the employee decides to sue you, the LLC, for some reason or another. But we can talk about tips later on that.
Okay. Yeah. So within, I feel like what I get asked most often is, or what applies most often is professional insurance. And so the way I understand it, within professional insurance, there's kind of two different avenues where you could get general liability or the errors and omissions, like you mentioned. Is that right?
Mm-hmm. That's right. Errors and omissions is what's most relevant, say, to attorneys, to accountants, to architects, any of the professions that really place a high degree on intangible advice that's provided to the clients. And we need to make sure that that advice is as accurate as to the facts and circumstances presented by the client. So errors and omissions is really important. I'm not, and again, it just depends on the circumstances of what else might be needed. So having a good insurance broker to walk you through what they see other professionals use as part of their bundle of coverage would be a really good idea to do. And that's to have a good conversation with, what else are professionals purchasing in addition to errors and omissions and maybe general liability. And you'd be surprised to learn that they're doing business in a different way, and that's why they have additional coverage, and some don't have all that additional coverage.
Yeah, yep, absolutely. I agree with that. That, like we talked about with the IRS, you should probably talk to your CPA about the specifics of your situation. And then for your insurance, I think it's helpful to know just the general protection that's available out there, but you should always consult with your insurance agency or your broker on what's the best
That's right.
approach for you.
And another good resource for entrepreneurs to consider is really reaching out to other entrepreneurs and saying, hey, what do you carry? And they may open up and tell you what they carry.
Mm-hmm.
Some may not, because it may be confidential to them, but that's perfectly fine. You don't lose anything by asking. And it's just all related to the circumstances. For example, I have a home office, and as a result, I don't carry general liability for a premises. I don't invite my clients to my home. I visit my clients at their business operation, at their places of operation. And so that changes the dynamics for the type of coverage I need. And so it's also advisable for you to just reach out to other professionals in your area that you admire, and see if they want to share some of these details. But most likely your broker should have a good sense for what is benchmarking in your area.
Okay, great. Yeah, that's
Mm-hmm.
useful information to have. So, okay, so we've talked about the LLC, we've talked about considering insurance. So let's talk about contracts. What
Mm-hmm.
are the contracts that you see are most often used? And what are some things that that business owners should consider including in those contracts?
Sure. So because we're talking about all things LLC, let me start off by talking about the most relevant contract for an LLC, and that is an operating agreement. The operating agreement is basically an agreement between the LLC, which is now this legal entity, and the founder or founders that created the LLC. It says, we, the members or member, have created this LLC. Here's how we're going to run it. Here's who is going to run it. Here's how we're going to allow new members to come on board. Here's how we're going to terminate membership. Here's how we're going to allocate losses and gains. Here's how we're going to do a number of other things depending on how complicated you want your organizational document to be. But it's the number one document that you should have in writing. It is super helpful for yourself. And it is also very helpful among members who may have a disagreement later on. And it's really very helpful and useful to have a document who says that you agreed to do this way, not the way the member may be proposing at a later time. And again, having a clause that says how that contract is going to change or not change is part of the process as well. So there's peace of mind in having an operating agreement for your LLC, even if it's just with yourself as a single member. Now, the LLC is likely to become an employer at some point in time. So we'll talk about employee contracts and some tips there. And the LLC is also likely to have, of course, it has to have clients. And that's how it's going to stay in business. So let's talk about the employees who will help the LLC succeed in designing and creating the products and services. I would recommend that a real simple employee contract be in plain English. Try to avoid legalese as much as you can. And if you have to have them, absolutely have them. But by and large, make your employment contract readable. Why? Because you're going to give a copy of that agreement to your employee, and here are some of the things that they need to clearly understand in plain English. Number one, scope of duties. Why did you hire them? What are the expectations that they are going to be fulfilling for you until you change their job description? So that's really important. As an employer, the LLC will have to monitor performance. So if you have any performance issues, it's good to have a scope of duties that your employee needs to meet. And then if you ever need to separate from or terminate an employment relationship with an employee, it's good to know that you had a scope of duties that may not have been satisfactorily provided to the employer, or for any other corporate reasons, such as other policies that are not in the scope of duties, but that's just an aside. The next clause that you want to have is compensation. People need to know, and the employer should record what the arrangement for compensation is. And sometimes folks forget compensation because they are working with a member who started the LLC. They've known them for years and decades, and that's just a clause they may overlook, but it's really good to have it recorded somewhere. Again, for purposes of knowing exactly what the arrangement was. And then another clause that I find to be super protective of the employer, the LLC, is at-will employment. It's really important that employees know that just because you have been friends or may really well know the founder of the LLC, your employment relationship may come to an end sooner or at some point in time that you may disagree with. But again, it's at-will employment. And while we're speaking about at-will employment and terminations, one of the other clauses that I'm starting to ask most folks to include, even if they're a small, very small business, is confidentiality. Many of you have worked really hard to build your book of contacts, your book of business, your secret recipes, your way of doing something, or delivering a certain product or service. And because of the nature of the volume that you may have, you're involving other employees to come in and look at this information. You should treat it confidential. So I strongly urge many of the small entrepreneurs to put a clause that says anything that is confidential in the company is confidential, and employees don't have a right to publicize that information or take it with them when they do move on to another position. Some LLCs are involved in marketing or design or artwork, and that is now requiring what I would consider an I for work for hire clauses. If you have a marketing service that produces logos or trademarks or service marks, and you hire a graphics designer to help you with some of the volume of peak season or whatnot, you want to make sure that that work that's being produced for the LLC is work for hire, which means the LLC owns the rights and has ownership over that property that's performed on their behalf. Mm-hmm. Now, lastly, I think one of the most important things, I think it's pretty standard in very big corporate employment agreements, but I'm not too sure how it is perceived at the very small entrepreneur level, is mediation or arbitration clauses. One of the things that I advise folks to think about is that sometimes employees and employers will need to separate, and there may be disagreement over that, or and as a result, it'll generate some legal employment related issues that need to be managed. And so going to court becomes a question of cost because it takes money to defend in court. And number two is your reputation will become a matter of the public sphere. So if you have been working really hard as a small business employer to build up goodwill in your community as being a responsible business and contributing to your community, the last thing you want are serious allegations of being disputed openly in the court system. So I always say, it's a good idea to start off with mediation, where you try to work things out between the disputing employee and the LLC employer and try to figure out and find a solution. If that doesn't work, then escalate it up to arbitration, where you do hire, you would hire professional mediators anyway, but in the arbitration sphere, you bring in an arbitrator to resolve the differences between the two parties. That decision is binding, subject to some limitations, but that would be putting me down into a rabbit hole of sorts. But just to say, it's good to have a mediation clause and arbitration clause in your employment agreement. And then depending on the type of work that your company does and the type of book of business that may be involved, you may want to talk with a lawyer on this one, not a CPA or an insurance broker, but a lawyer on a non-compete clause, because there are some industries that are highly competitive, and you bring in an employee, you build them up, you train them, you invest in their knowledge base, and they leave for a competitor. And it may be an employee that is a very high performing and critical component of your success as a small business. So having a non-compete may be a proactive, smart way of making sure that your competitors don't hire away your talent at your expense, to your detriment. So, but that's, for very select circumstances, it's not viewed well to be used for, say, a non-compete and the janitor that cleans your company's premises. It's just not a good combination there, but for a number of different reasons. But again, this is where you want to bring the lawyer to help you understand what your options might be in a very sensitive, competitive market. And of course, another one would be a non-solicitation clause, basically where your employees don't solicit your base of customers for any of the work that they're performing for a new employer.
Mhm.
So those would be some of the clauses that I think, in the order that I presented them, would be very helpful to have. And the further down they are, the most likely it would be really good for you to speak with an attorney about that,
Yeah.
about those.
Yeah, absolutely. A key thing that I see and a distinction that I want to make is,
Mm-hmm.
so we talked a lot about the contract with the employee, but for a lot of businesses, they are using independent contractors, and you touched on that briefly. Do you mind explaining the importance of having separate contracts between full-time employees and independent contractors, and maybe a key distinction that you need to make if you do have independent contractors?
Sure. Well, I'll try to be as helpful with that one, because independent contractors are an area of legislative interest. I think you've heard of AB5 out in California. And also a number here in Iowa, we do have I can't remember the proper name of the agency, but it is of interest to states to make sure that employees are properly classified so that their rights can be protected as well. So independent contractors are a facts and circumstances type of a review. If there are generally no bright line quick rules. There are some parameters around that area, one of which would be, is it ongoing business engagement, or is it like a project that's only done once for an LLC or an employer? And who has the control over the way and manner in which those services are being performed. The more control the individual has over the way they deliver the services or the product, the more independent they look from being an employee who has to deliver a product or service within the parameters and specifications of an employer. So there's a number of different angles to look at, but generally I would say that it's a good idea to have a contract for your employees, especially the ones that are even if they're part-time, but consistently there to assist you in performing your operation, so that you can stay in business. Have a contract with them that has their part-time status memorialized,
Mhm.
and their benefits and any other characteristics that are important to that relationship. And for your independent contractors, make sure that you have a clause that acknowledges that they are acting as an independent contractor, so that they're not left with the impression that there's anything but an independent relationship between the LLC employer and themselves. And it doesn't have to be fancy legalese. It just could be a clause or a paragraph or a sentence stating that they acknowledge they're an independent contractor and that the employer has no control over the way this service will be performed, but that they expect that performance will be done, will be delivered with craftsmanship and with the care and diligence that is customary in that trade or service that the independent contractor is in.
Yeah.
Again, as you just heard, you probably want to talk to maybe a lawyer to get a sample clause, or talk to a friend who may have a sample clause in their agreement if they already have one. But it's a good idea to have an independent contractor agreement, no different than your vendors. So you might want to even treat them that way as a vendor. You have an agreement for delivery of supplies, that's a vendor right there. They're not a contract, an independent I mean, they're not an employee, but they're a vendor. And your independent contractor is something similar but less frequent than the vendor.
Mm-hmm. Yeah, and to simplify it even more, so I think most people understand this, but just to provide a few buzzwords. So I see a lot of independent contractors are VAs or virtual assistants, people who are doing graphic design, social media management, digital marketing. And so obviously you're not, if they're an independent contractor, I just want to clarify, then the employer is not paying their benefits. They're not paying their Social Security or their Medicare, their employee taxes. And so it's very important that you work with a lawyer to write up that contract with your independent contractors that clearly states you are not a full-time employee. I'm not paying your benefits. So.
And that's part of the that is part of the argument for why some employees do want to be viewed as full-time employees and not classified as independent
Right.
contractors. And that's because they're missing out on all of the benefits that an otherwise fully recognized employee has. And
Exactly.
but by the flip coin, there are people who really do want to be independent. They don't want to be bound to an employer. Maybe they have maybe they have better economic opportunities. And I've run into this one before where a graphic designer can take up multiple assignments and make a lot more money in that regard with multiple projects as opposed to staying with a very small employer who can only provide them with a steady stream of compensation. So they'd rather roll the dice and go out on their own and scale their services to the point that it makes sense for them to be independent.
Mm-hmm.
And I've, 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 I've seen it in both directions. So it's, what I say is be very careful with your employees. Make sure that you're classifying them appropriately. If you have an agreement, I think that's the right way to start, and blame the LLC as to why you need to put something in writing and say, hey, just for purposes of documenting, I need to document your employment relationship, despite the fact that you have been a very good customer, very good friend, or very good independent independent contractor. And last 2-3 years when I've needed assistance, you've stepped up to the plate to help my LLC business, but now I need to be a little bit more formal because of the LLC requirements. And I'd say blame it on your business model that you need to document this type of arrangement or agreement.
Mm-hmm.
And I will tell you, Jamie, that the more successful a company becomes and the broader their client base grows, the more they get comfortable with starting with written agreements. But the smaller the company is, the more relationship driven it is. Sometimes they're a little hesitant to come out with a 1-page or 2-page employment or even an independent contractor agreement for the delivery of services.
Mm-hmm.
So it just depends, but I do want to remind your viewers that even if you don't have it in writing, you can still be making a lawful agreement. So verbal agreements are recognized. They still have the same weight and force as a written agreement. So be careful what you say and what people rely on what you have to say. So that's important for them. But again, visit with your attorney. A general practitioner attorney can help. A labor attorney can even be more helpful because that's their specialized area. But either way, consulting with an attorney is the right thing to do when you are uncertain as to how to better position your company from liability from independent contractors who now want to be classified as employees who lost wages and compensation benefits from your LLC in the last year or two, or however long they allege they were not allowed to participate as a full employee.
Yeah. So do you have any other legal tips for entrepreneurs or business owners?
Yeah, a couple of things with your client contracts. and then your operating LLC contracts. So let's talk about with your clients. When you have when you have a client and everything is going great, make sure that your client agreement for what you're selling them includes a scope of service and products. So it's your scope of service, a payment schedule, also a mediation or arbitration clause. Again, same theory. You don't want your unhappy customer going out to the courts and making a number of allegations out and a matter of the public record. So be fair, do some mediation, and try to resolve it no later than arbitration. And put a limitation on liability for your services. So for example, if you're unable to deliver a contract for services, and the services cost, say, $1,000, then try to limit your liability for those services to no more than anywhere between 1 to 2 or 3 times the amount of the services. So you don't end up with a customer who wants to claim damages, say, of 10, 15, 50,000, or who knows. Just limit your liability in that regard, and help them understand that that's all they're agreeing to limit that. There may be some considerations when a court may not want to honor that, so check again with an attorney to make sure that your limitation of liability is within the public best interest and doesn't run afoul of some of those nuances. Termination, it's always important to know that parties can walk away from an agreement, and how to walk away is important. So if your client is dissatisfied or your client wants to move on to a competitor, they're able to provide you with notice is typically the way to go, and say, I'm going to pursue other opportunities, thank you very much. But you're not left wondering whether you have an agreement or not. So it's always good to have a termination clause in there for your clients. Other legal tips, Jamie, that I think are relevant to the LLC are: number one, make sure that you keep your business identity separate from your personal identity. Many starting entrepreneurs have been solo proprietors, meaning they've been doing all the work and all the services out of their home for a number of years, and they've been filing taxes in their name. They've never had the benefit of an LLC or any other corporate mechanism whatsoever. And now they are dealing with this LLC creation that has the advantages of limited liability and pass-through taxation. But I always say, make sure that you keep that identity of your LLC separate from yourself. A couple of ways to do that. Number one, when you sign anything related to your LLC, make sure that you're signing with your name, your title, and the name of the LLC. Sometimes the instrument or the document you might be signing already notes that it's the LLC that's engaged in the document, but it doesn't hurt to once again be the signature, that sign off that says Sylvia Casada for SQ Advising. And so again, it's the entity that's signing. Make sure that you get an employer identification number. If you are fortunate to be a sole member LLC, you're not required to have an EIN number for your LLC, but it is strongly encouraged that you do. For tax purposes, the IRS doesn't care that you have that EIN number. They're going to look straight down to the single member and verify that whatever losses or profits you claimed are accurate. But when it comes to your having a bank or checking account or a debit, they all want to see an EIN number. So get one, and it also reinforces the separation of identity.
Okay.
And then so does that make sense for you? Or
yeah.
Okay, perfect. And then the last tip around the LLC is make sure that you have something in writing for your operating agreement. You don't want to default to Iowa law without having the benefit of working out a better deal for yourself. When you do an operating agreement, you're controlling a lot more what type of management structure you want, what type of calendar year for taxation or not you're going to use, um, how you're going to terminate or onboard new members, and a series of other areas that are advantageous for you to take control of. So I always say don't default to state law if you don't have to, or if you don't want to. At least default it because you never got around to doing an operating agreement. But by and large, try to control your fate by doing an LLC operating agreement yourself. Not yourself, but I mean, set one up for you to operate with and follow it. And in the course of following your operating agreement, you find that, it's difficult. I don't want to have a meeting once a year. I'd rather have a meeting every twice a year, and I'd rather have the meeting notice work this way or that way. Those are all nuances of your operating agreement. Change your operating agreement, amend it, and restate your operating agreement so that it reflects the practices that you can best follow and be in compliance with. And that sets you up to continue to keep a separation of identity between your LLC and yourself as a natural person or the founder of the LLC. And so with that in mind, it makes it a lot tougher for any court to try to pierce the corporate veil at a later time. And that is a concept that we probably want to talk at a later time. It's called piercing the corporate veil, to disregard the LLC from liability protection. And the more separate your habits are from the LLC and your personal household, the better off you're going to be to fight something like that.
Great. Well, these are all wonderful tips. So where can people find you if they do have questions? Do you mind mentioning your website again and how people can get in contact with you?
Sure. So my website is sqadvising.com, and my telephone number is 319-541-3321. And my email is sq@sqadvising.com. And I'm always looking to help our entrepreneurs get comfortable with using many of the tools that many of our large corporations make use of on a day in and day out basis so that they too can make their business more successful. So I'm always happy to take consultations, and then once we agree upon whether they want to proceed with engaging me as an advisor or a consultant, we can discuss the scope of services, schedules, etc. The same tips I passed along here. So thank you, Janie, for having me here today. It's been a pleasure, and I hope your audience finds this helpful.
Yeah, I'm absolutely sure that they will. Thank you so much for your time. Do you mind providing your general disclaimer just one more time? About
Absolutely. So yes. So the general disclaimer, the housekeeping disclosure I have is that the information provided in this web streaming service is for educational or informational purposes only. It is not meant to be relied on as legal advice. Please consult with myself or an attorney for very specific, for more specific addressing of your facts and circumstances to get applicable legal advice for your LLC or your business that you're running at this time.
Great. Thank you so much, Sylvia, for your time. And if anybody has any questions, please feel free to reach out to Sylvia. So thank you so much.
You're very welcome.
Great. I would cut it off right there then. Yeah.